Welcome to the West Michigan News Company, Logical News. My name is Pat Foster. I'm the editor. Logic is based on facts, and facts are then taken and logical conclusions are made. So we're going to do something a little different. We're going to put the cart before the horse. It's like telling you the punchline in a joke and then telling you the joke. We're going to tell you the facts first, and then we're going to tell you the issues that arise from those facts. Under Michigan law, MCL 169-235-2, that specifically exempts judges and Supreme Court justices from filing their campaign finance reports. Just right offhand, that might not mean very much to many people, but it in fact allows judges to take campaign contributions into an account, and they can be large contributions from people that they're hearing cases from, and they can sway their decision in favor of those persons. Now, Michigan law, the Michigan legislatures knew exactly what they were doing when they did this law, because it's a public document, and all public documents are subject to the Freedom of Information Act. So you should be able to get in the front door and ask the judge, I want to see your campaign finance reports. But under the Freedom of Information Act, MCL 15.243.1, lists exemptions that you specifically cannot see. And exemption R is records of a campaign committee. Now, the only campaign committee that isn't a public record are the records of judges and justices. And so that gives them an open and shut place to actually take major contributions, call them contributions, but they're really bribes. They're bribes to get the judge to sway their decision. And in the court, if a judge makes a decision and it's not based on the law, the higher courts are going to accept it, even though it's called an abuse of discretion. How do we know that the state of Michigan is not just an anomaly, that all the other states don't have this conflict of interest, that this is just particularly subject to the state of Michigan? Well, I tell you the truth, I have not researched the other states, but there is a Supreme Court case that would seem to indicate otherwise. And that Supreme Court case is Caperton versus the A.T. Massey Coal Company. The A.T. Massey Coal Company is a West Virginia company. They were subject to these 23 coal miners dying several years ago. They were in the news because of unsafe conditions at their mines. And in this Caperton versus Massey, Caperton was a member of a group that had been pretty much put out of business by the Massey Coal Company. And this Blankenship, Mr. Blankenship, who was the CEO and executive officer and chairman of their board of the Massey Coal Company. And Caperton and his group won a lower award at the lower court level of a $50 million decision. So what Blankenship did was he put up $3 million through alternative companies that he was associated with to finance this Benjamin's campaign running for the Supreme Court of West Virginia. And Benjamin beat the incumbent based on this $3 million that was put up by Massey. And then Massey turned around, appealed this decision to the West Virginia Supreme Court. the West Virginia Supreme Court granted, and they were going to hear this motion. Caperton brought a motion for Benjamin to recuse himself because of this money that he was granted. Benjamin refused. Then the court overturned the lower court's decision and took away this $50 million decision. And so Caperton appealed to the United States Supreme Court. And in a 5-4 decision, the U.S. Supreme Court ruled in favor of Caperton. And this was based on campaign contributions. Now, the Supreme Court, this was indirect campaign contributions. The Supreme Court was trying to bring a point here. They established 2 standards that needed to be met. One was you had to have an abuse of discretion. And an abuse of discretion alone could not force a judge to disqualify themselves. But an abuse of discretion with an extraordinary circumstance like they're receiving campaign contributions would force them to recuse themselves. And so that leads me to believe that every state where judges are elected, we pretty much have this same situation, because this was an overall problem that the Supreme Court was trying to address. These judges throughout our country. How can we defeat this? I mean, if the state legislatures have done this, how do you change things? Well, we say you vote out the people that are in the state legislature, but most of you are going to say elections don't mean very much, and you're right, they don't. That's another conflict of interest. Article 2, Section 1 of the United States Constitution deals with, the articles deal with how things should be done. And this is the only area that involves elections. In paragraph 1, it says this is how elections are to be conducted. Paragraph 2 states that no one in government in a position of trust or profit shall have anything to do with elections. Trust are people who are elected to government. Profit are people who work for the government. So they cannot be electors, and electors are all people within the private sector. They are not in the public sector. They should not only not be running elections, they should, but they shouldn't even be voting in those elections. So if you go to vvvotes.org, that's a 501c3 nonprofit organization I established. It has 2 functions. One, to do ballots where people know the candidate's position on issues that are important to each voter. They know each candidate and how they stand on those issues. And 2, it allows the people, not government, to put the issues they want to vote on, like fracking, marijuana, the environment, war, any issues that are prevalent to the community. It is, instead of top-down government, it is bottom-up government. And it's the people locally gathering that create their own groups under Article 2, Section 1 of the United States Constitution, and they vote. Now, there's no guarantee that government's going to accept those votes, but there certainly is no guarantee they're not, because they're going to have to tell us why they are not complying with the United States Constitution. And I think they will do that. So that means that people can get together set up their own groups, and that's what VVVotes does. VVVotes.org does not set up the groups. You are responsible for setting up your groups. All we do is provide software to you, and we will put information on the ballot so that you want. And the software is designed so that each voter can find their vote in an official database after the election's over and check out their vote compared to a printout of the vote they have and know that that's exactly the way they voted it. And as a CPA, I can assure you that that is the best system for checking and auditing elections. Thank you. I really appreciate coming to you this evening. Bye.